welcome everyone. I'm Professor Trish Mundy, Chief Integrity Officer and Professor of Law at the University of Wollongong. And it's my pleasure to welcome each of you here today. Our Luminaries panel brings together leading UOW researchers, industry experts and thought leaders for a 1-hour conversation every fortnight. We will discover how collaboration at the University of Wollongong is tackling global challenges. Before we start, I would like to acknowledge country.
We acknowledge that country for Aboriginal peoples is an interconnected set of ancient and sophisticated relationships.
The University of Wollongong spreads across many interrelated Aboriginal countries that are bound by their sacred landscape, an intimate relationship with that landscape since creation.
From Sydney to the Southern Highlands to the South Coast. Freshwater to bitter water to salt. From city to urban to rural.
The University of Wollongong acknowledges the custodianship of the Aboriginal peoples of this place and space that has kept alive the relationships between all living things.
The university acknowledges the devastating impact of colonisation on our campus's footprint.
And commit ourselves to truth-telling, healing and education.
Wonderful, incredibly powerful. So today is International Day of Consent. A day to focus on consent as a practice and as a tool for making positive change. To mark this day, we bring together experts to explore consent and affirmative consent, what it means, how the law is currently working or not working to improve the experience of victim survivors, and how it complements existing prevention programs. So the webinar also aims to shed light on further reforms that warrant further investigation. And I'm really honoured to welcome our two panel members today. First of all, I'd like to introduce you to Professor Julia Coulter. Julia is a leading Australian expert on sexual assault law reform, and her research investigates the barriers to effective translation of progressive statutory reforms into criminal justice system practices and the implications for victim survivors. Professor Coulter is currently leading an ARC discovery project evaluating how intoxication evidence operates in rape trials and whether efforts to break the culturally assumed nexus between intoxication and consent have been effective. Thanks, Julia, for joining us. We really look forward to hearing from you. Our other panellist is Dean Cooper. Dean is a violence prevention specialist with the Mate Bystander program at Griffith University, delivering gender-based violence and respectful workplaces training across Australia. And much of Dean's passion for working in this space comes from his experiences of playing rugby union and the problematic behaviours he participated in, he says, whilst in sporting environments. So Dean has achieved a career working in various roles within the criminal justice system in both metropolitan and rural Indigenous communities. Dean is currently partnering with UOW's Safe and Respectful Communities team to roll out bystander intervention training to UOW community and motivating senior men in particular to take personal and professional leadership in preventing gender-based violence. We're really excited to have you here with us, Dean. So thanks so much for joining us. We encourage members of the audience to submit their questions using the Q&A function. I'll keep an eye on those when we get to later in the webinar, and we will try to get to as many of those as possible. I do want to begin by acknowledging that the material covered today is heavy and difficult content and contains potentially triggering content for victim survivors. So if you need support, we encourage you to please call or text our free UOW Student Wellbeing Support Line anytime, and those numbers will be in the chat for you to access. So let's get underway. And Julia, if I may start with you. So previous law reform and the adoption of the affirmative consent model have been recognised as significant advancements for victim survivors in sexual assault trials, although I know that you have your thoughts about, you know, the success of that or otherwise. But I wonder, can you provide an overview of your work in that area in terms of how experiences for victims in, in sexual offence trials have changed over time?
Yeah, thanks, Trish. Look, I've been looking at this research for a long time now, over 30 years, and I think it's really important to situate the most recent affirmative consent changes across a 40-plus year history of what I would call good-willed progressive law reform in this space. And I think that's, really important to recognise, because often I tell a very negative story in this space, but we actually have had really good-willed legislative change at every turn. Most of that reform has been about combating what was the common law experience in relation to sexual assault trials, which predates about 1981. And the focus, of course, for common law offences was based on whether or not the woman resisted the attack and the need to show some kind of physical injuries, and in addition to make a very quick and immediate complaint to police. And often at trial, she felt like that she was being really tried in terms of the offence, being attacked about her sexual reputation and her sexual history evidence. So that's kind of where we started, or we can set the scene from. In 1981, there were really important reforms that shifted our understanding of the offence, moving from the notion of resistance to that of consent. So the key word being that big change in relation to consent. And since 1981, we've done a lot of development of what consent means. In 2007, we got a really important definition of what that means, which is meant to be free and voluntary agreement to the sexual activity at the time of the offence. And of course, our most recent iteration is that of affirmative consent. And just for listeners, I think it's important to recognise that the idea of affirmative consent often has a kind of a bigger social meaning than it really does in the law. Because in the law, affirmative consent really goes to the component of the criminal offence that deals with the guilty mind. And what an accused person needs to show in order to demonstrate that their belief in consent is reasonable is that at the time, or in a relatively recent time before the sexual activity, that they said or did something to affirm consent. So it's quite limited. It relates only to the component of the offence that deals with the guilty mind, not the act. So I think that's just important to distinguish. But in addition to these really, I think, very transformative aspects of the legislation, we also have introduced a huge series of protections for complainants to try and improve their experience in the courtroom. And some of those have been more or less successful. Some of those things include what was commonly known as the rape shield provision. So to protect complainants being asked questions about their sexual reputation, and also to moderate the types of questions that they might be asked about their sexual history. In addition, we've had really massive changes in the way complainants give their evidence. So most commonly now they give it remotely by way of CCTV footage, so they don't have to see the accused person in the courtroom, because often that is recognised to be a very triggering and very difficult thing for a complainant to do. Complainants generally these days have support people with them. Courtrooms are closed whilst they give their evidence. And I think importantly, there's a non-publication order as standard practice backed by a criminal offence in all trials. And I'll just say one last reform that's happened over this period of time, and that relates to jury directions. It's recognised that in this area of the law that there are a large number of what we refer to as rape myths. So the idea that complainants would immediately make a complaint to police, that they would consistently and without wavering, no matter what the context, report their story, both to the police but also to others, and a range of other things. And so we've used jury directions as a mechanism to try to explain to juries that these expectations of the quote-unquote true rape complainant are not actually what the empirical evidence tells us. So, for example, it's much more common for a complainant to delay in complaining, that trauma impacts memory, and so things to do with the way in which the story may unfold, whether that's to police or to a forensic officer or to a friend, may well demonstrate inconsistencies. And that's also a product of human memory. So I think it's really important to see this most recent reform across a very wide landscape of 40 plus years of change, where I think the legislature, backed by, I think, feminist activism to change things, has really accommodated problems and tried to change things for the better in terms of the experience of complainants in the courtroom. Whether that's been successful, we might come to a bit later.
In fact, we will. We'll certainly explore that a bit more later. Thank you. That's really interesting. So that kind of 40-year shift from notions of resistance to consent to a kind of focus on changes to the way victim survivors give their evidence, to focus on jury, of that really tracking over 40 years to the currently where we are around affirmative consent. And legal responses, sit preventive, prevention initiatives. I think that's, really critical piece as well. So those legislative reforms that, Julia has talked about, and I guess most recently the, affirmative consent, have presumably changed the way organisations work to prevent forms of violence. And I wonder if you can share or give us an overview around how things have changed in terms of prevention and education over that time as well, and where we're currently sitting. I think we seem to have a freeze with Dean. Hopefully, here we go. Dean,
I thought we might have dropped out then. Always an IT problem. It wouldn't be a panel without an IT issue somewhere.
Exactly. So, Dean,
yeah,
did you hear what I said? Fantastic.
I got the question, and then as I started talking, it paused. So okay, I'll restart that. Apologies,
Thanks,
everyone. How the landscape has changed when it comes to prevention and education. We've seen law changes such as affirmative consent, the Respect at Work bill, even the government announcing now potentially a national plan around addressing sexual violence on university campuses. What these changes have started to focus on is changing the way in which we support people who experience these behaviours. So traditionally our responses, whether it be in a HR capacity, a legal capacity, if you have been the victim of sexual violence, it is up to you to go and make the report. At work, if you're a victim of sexual harassment or you experience sexual harassment at work, the onus has always been on the person who experiences the behaviour to be the one to do something about it. And oftentimes that's a very isolating, traumatic, difficult experience to follow, as Julia pointed out, with some difficulties with human memory and traumatic, triggering events of revisiting and constantly revisiting and giving statements and seeing the person who has perpetrated the act. So what we try to do, and what these prevention strategies and education piece we're focusing on now, is taking the onus off the person who experiences it, because we've often expected people when they're at their lowest to be at their strongest, to follow through with these really difficult and rigorous processes of raising complaints. And so we want to take that onus off the person experiencing the behavior and place it onto people around. Because as we know, people witness, they know, they hear, they sense that something might not be right. And so what workplaces are moving towards is providing education to others around. So to equip people to have the skills to intervene early in a preventative way, that we understand that we don't start a university campus or an organization tomorrow, and then on day 2, we have sexual harassment occurring. These things happen on a continuum. And the education piece is really understanding that at the start of that continuum, you might have problematic language and jokes and objectification of women and these things that precede larger forms of violence. And then right down the end of that continuum, we have sexual assault. And what the education piece is looking at is that not saying if you've ever told a joke or laughed at an inappropriate joke that you are going to perpetrate sexual assault or rape, but those that do have usually stopped at each stop along the way. And that's really the job of that prevention piece, is to understand early on how these behaviors really support and allow a culture to occur in which these behaviors occur and happen. So that landscape of the changes has really been that preventative piece of not just a crisis response model of recognizing, responding, and referring. We're absolutely getting better at doing those processes as well in more trauma-informed and caring ways. But there's absolutely been a landscape shift into the preventative nature and the uptake of bystander programs to equip people with the skills to show support and hold people gently and respectfully accountable before we see those really big incidents that are concerning.
Fantastic. And Dean, I think we'll come to later, more about the bystander training itself. And I'd be really keen to hear about what some of the key elements of being an effective bystander are, because it is a fantastic training program, I've got to say, exciting, with the capacity to stretch across all sorts of, behaviours, I guess, not just gender-based violence, but a whole range of behaviours. So we'll absolutely come back to that. Thank you so much. Julia, just following up on your last point around affirmative consent. So obviously many over the years have questioned the extent of the law reform, about whether it goes far enough, its efficacy in addressing sexual assault as a social issue. And as you pointed out, how we understand it in law and how we understand it socially, 2 different things. But I'm wondering, can you provide some insight, and particularly drawing on your research, which I know has been over many years, some insight as to what's not working at the moment, or opportunities that you see for further reform?
Thanks, Trish. Look, I think I should start with the good news story first. So rather than going straight to what's not working, because
thank you,
I can give you a fair bit of that. But look, some of the things in our studies that we have seen that are working are a lot of those general protections in the courtroom are working really well. So the fact that a complainant now, pretty much as standard practice, gives evidence in a remote location by way of CCTV footage with a support person present, that's a really positive reform, and it's working well. Courtrooms are generally always closed now, and non-publication orders are basically standard practice, so nobody can identify the complainant in a particular proceedings. Those things are working well. I spoke before about what I call the rape shield provisions, so trying to prevent sexual reputation and sexual history evidence coming into the courtroom. And what we've found across our studies of trials is that the reforms that have been introduced are being followed. They are still managing to raise sexual history evidence pretty much in half of trials that we've looked at, but the standard procedures for doing that are followed. So there is an application, there are submissions being made in the courtroom, some things are being rejected as questions, and so there's a procedure going on. So those things are working actually pretty well. Let's then come to the kind of bad news story. And I suppose, given our discussion today is focusing on the concept of consent, is unfortunately we've found very little evidence that in the courtroom, this transformed concept of consent as free and voluntary agreement, and the notion that there's meant to be a communicative model of consent at play, is just not playing out in the courtroom. We are still seeing very much a focus, and this is both by the Crown, because often the defence are the ones who are up for criticism, but I make this criticism both of the Crown case and of defence, is that there is a strong emphasis still on whether or not the complainant physically or verbally resisted the particular attack. And we're also seeing that a whole range of the kind of real rape attributes are entering the courtroom very commonly. So questions about whether there was an immediate complaint or not, typically allegations about them delaying their complaint. In terms of the consistency, there is nearly always an allegation that the account is not consistent enough. And generally speaking, complainants are cross-examined on two things in particular that I find really problematic. One is their so-called pre-event behaviour, so the things that happened before the sexual assault occurred. And that is often characterised as flirtation, and that then is led to suggest an inference of consent, which of course is not what either our understanding of consent should be based upon, nor in terms of affirmative consent, this affirming whether or not consent was going on. So that's one area. The other really problematic, or I think troubling area for complainants is the kind of range of topics that they can be asked about. And so that can range from everything to do with histories of substance abuse, mental illnesses, whether or not they've got past criminal convictions, whether or not they've had their children taken away from them at particular points in time. Many of your viewers might think, well, how is that relevant to the sexual assault? And probably my answer would be, it's not, but they are things that are regularly asked of complainants. And the other thing that is, I think, very traumatic for complainants is that in nearly all of the trials we looked at, complainants were accused of lying. And in about 3/4 of those matters, not only were they accused of lying, but there was a particular motive, many of which seemed very fanciful reading the transcripts, but nevertheless were imputed to the complainant. So it's not, I don't think, the fact that lawyers and judges are not reading the rules and the changed legislative landscape. Rather, I think the problem here is that most of the positive reforms that we've seen over the last 40 years don't go to what is at the heart of the really traumatic experience for complainants in trials, and that is the adversarial nature of the proceedings, the fact that they are allowed to be asked such sensitive and broad-ranging questions that seem to have very little to do with the actual sexual assault. So none of the reforms are going to those particular things. So what can be done, which I think was part of your question? We've made some modest suggestions, I think, for further reform, noting, these waves of successive reform. But one of those is to introduce what are called ground rules hearings. So it's a kind of a pre-trial mechanism to kind of discuss what should and shouldn't be asked and how things should and shouldn't be asked. Now, it may not prevent those sensitive questions being asked, but what it will do is alert judges to what's in, what's out, and how those questions can occur. So that's one thing we think, and that's been introduced in Victoria and some other jurisdictions overseas. And then the other thing I think that really needs to happen is that the Crown really needs to model its case on the idea of free and voluntary consent, not focusing on the real rape attributes, because otherwise what we see is there's just two sides of the one coin going on. The Crown says, well, she did resist, and the defence says she didn't resist enough. We need to focus in on what the legislation says, that was there free and voluntary consent to the sexual activity at the time. And that's something we're not seeing in any of the trials at the moment. Yeah.
Thank you, Julie. That's really interesting. In terms of your proposals there around the notion of a ground rules hearing, is really interesting. That second point you made around the prosecution and the focus on the particular requirements under the legislation. Could you just expand on that a little bit? I'm just wanting to understand exactly what your suggestion is there. Is this basically where you're saying the prosecution and the defendant's case are not focusing sufficiently on exactly what is required to be shown under the legislation. And so there's a real need to focus at a pre-trial stage on that. Is that what you mean?
It is. So I guess in terms of the Crown, and the Crown obviously needs to frame the case. They have lots of ethical obligations to, you know, tell the whole story and present all of the evidence. So I accept there are obligations on the Crown to do certain things in particular ways. But what we've seen in trials is there is still a focus on asking complainants questions about, so did you scream at that point? How loudly did you scream? Did you fight the defendant off? Now, there is nothing in our legislation, in fact, to the contrary. It not only says that we should have free and voluntary agreement, but since 2022 in particular, it says if the person doesn't say or do anything to indicate the consent, there is no consent. So this focus in on what the complainant did or didn't do to resist the attack is very closely mirroring what we had, you know, 40 years ago under the common law system. So that's very troubling. But it's also too that the Crown tends to still run its case around what I've referred to as either those real rape attributes. So if they have evidence of recent complaint, they run that. If they have evidence of a consistent account, they run that, even though the law has been at pains to indicate that that's often not how humans respond in these situations. They do delay. Trauma impacts memory, as I've already said. Different audiences, you may tell the story differently. So, you know, if we're going to get change, I think some of that has to be led by the Crown in the way in which the story is unfolding in the courtroom. Yes. And until we have some of that change, I think we're just going to see, you know, she didn't, you know, consent, she did consent, and a very superficial reflection on what it really means to consent or not consent to particular behaviour.
And in terms of the ground rules hearing, and you said that that's been introduced in Victoria and some jurisdictions overseas, what's your assessment of how effective that seems to be working?
So because they're recent reforms in Victoria, they were only introduced last year. It's still a bit early days. But where we have seen this operating is in relation to what we refer to as vulnerable witnesses. So either in relation to children who are giving evidence or people who have either cognitive or other physical impairments. And so they work and in some of the trials we looked at, those ground rules hearings were working very effectively. So you may have somebody who is called an intermediary who may come in and say, look, this complainant needs to be asked these questions in this particular way, in this format. They need to be simple questions. They can't be compound questions, so double kind of questions in there, no knots. And they may need to give their evidence in a particular way. They need to have certain breaks. So we've seen it working very effectively in those spaces. Now, some of that is really just going to the kind of form or mode of the question, but I think it can expand itself to look at the subject matter of, well, why would all this pre-event behaviour be relevant? Why is it relevant to download a complainant's social media history and all of the text messages that may be 6 months old and interrogate the complainant in the stand about those particular things? So, you know, it's an attempt to kind of really focus in on what are the issues here and what really needs to be addressed in the trial. And of course, hopefully that will also reduce the time that complainants are kept in the witness box, both in terms of their evidence in chief, but also their cross-examination. So I'm hopeful that that may improve some of the ways that trials run. I don't think it will be the full answer, but you know, it's an improvement.
Yeah, fantastic. Thank you, Julia. Incredibly interesting. Dean, moving to you, and let's kind of zoom out or in perhaps on the university context. So the 2021 National Student Safety Survey found that 1 in 6 students had experienced sexual harassment and 1 in 20 had experienced sexual assault in a university context. University context meaning either on campus or off campus, but somewhere where there was another student or perhaps a staff member, but, you know. So obviously this suggests areas, of much improvement are needed. But I'm wondering if you can talk to us about some of the prevention programs and initiatives that are having real world impact. And in particular, I'd love to hear more about the bystander training that you're working on. As I flagged at the beginning in introducing you, you are working with URW to actually roll out some bystander intervention training for as part of our male leaders, cultural change and having male leaders at URW trained in bystander training, or bystander intervention, I should say. So I wonder, can you tell us a bit more about the bystander training that you're working on and any other particular program prevention initiatives that you're working on as a start? And I can come back to you after that.
No problem. Yeah, the bystander program is something that I deeply believe in and am really passionate about, and have left other careers to come here and do the work full time in the bystander program. The bystander program is that it is looking at the resources around that we have, and that's the people that see, hear, or know that something is going on, or might suspect something is going on. There's a lot of fantastic campaigns around "Are you okay?" and "It's not weak to speak," and a lot of a push to start having some difficult and uncomfortable conversations. But what do those conversations really look like? How do we actually hold someone gently and respectfully accountable and authentically show support? So the bystander program is exactly that, and the great work at the University of Wollongong with the Safer and Respectful Communities team there are fantastic around how we engage people to have the confidence to step forward and intervene. And part of that program is providing education around the genuine psychological and physiological barriers that come up for us when we're confronted with something that makes us feel uncomfortable. So we go through those reasons and what they are, and they're a list of reasons why good people find it hard to step forward and say something, not a list of reasons why bad people find one and choose to not do anything. So we really go through what makes it hard, and I'm sure we've all been in a situation where we've either heard a joke, we've seen an action, we've been on public transport and seen overt racism occur on a bus. No matter what the circumstance is where we've been a bystander, it's been difficult for us to intervene in that moment. So the bystander training looks at exactly that. How do we intervene early on to have conversations with somebody? And when we're thinking about the context of, we're talking about intoxication before and consent, where's the bystander's role in saying, when I see someone being plied with alcohol, I feel really uncomfortable. Where's the person's friend, the perpetrator's friends around to say, hey, I really feel quite uncomfortable that you're going to be left alone with this person and they're intoxicated and can't stand and going there. Like, I don't think that that's okay. And how do we get people to step forward and seek assistance and speak up and have conversations with people? So that's what the bystander program is about, is doing those difficult things and how we do that with suggested actions, particularly to male leaders that I feel passionate about doing that, because much of the times when we go into organizations to have conversations about sexual harassment and consent and respectful workplace behavior, we often hear not all men, and that's really normal that we hear that conversation. And statistically, they're right. It is not all men that are perpetrating this. But when I did my own self-assessment, when I first got involved in these conversations, I sort of felt not all men, but not all men were having conversations about how we prevent it either. I didn't see any of my people in my friendship circles advocating against it. And that's really been the systems that we have around. My journey into this space was through playing rugby. And then through a run of injuries and largely lack of talent, I had to find another career pathway, which saw me go into corrections. And I started facilitating anti-violence programs, and specifically family violence programs. So working with people who were perpetrating physical and sexual violence in the homes. And quite alarmingly, what I learnt in that conversation was a lot of jokes and chants that I had led in rugby club and university environments at Griffith University, where I went and played sport and attended uni games. Those behaviours that I participated in actually showed up in the rooms, particularly to minimise certain behaviours and actions. And the most horrific things I had heard were usually preceded or post with a joke that I had participated or laughed in, or it didn't hold someone gently and respectfully accountable for. So what I started to realize was that full journey, that not all violence, not all disrespect leads to violence, but all violence certainly started with disrespect. And that is what that bystander program is about, is having the skills for people to hold each other gently and respectfully accountable very early on, so we don't have to rely on trials that, as we've heard, can be improved in many ways and are very difficult and very traumatic. And we really want to focus on the culture that allows and supports this violence to occur, because it is absolutely 100% preventable.
Yeah. And I think importantly in what you've said there, Dean, is that actually we don't we don't gently and respectfully call things out because for a whole range of reasons. And it doesn't necessarily mean because we're bad people or any of those things. There's a whole range of reasons why we don't. But your bystander training talks about, okay, one, it's about the awareness, and two, then it's about, okay, let's assess the situation and how can we then be an effective bystander, whatever that means in the context. I wonder if you can talk to us a bit about those principles around being an effective bystander, because I know your program actually talks about, was it 4 or 5 principles around that? Do you want to share just briefly with us? Because I actually think it's a fantastic program too.
Thank you. Yeah, no, it's really true. I think there's a few core principles that we stick to. And number one is realizing there's one thing that when we want to hold a perpetrator of sexual harassment or sexual violence, we're seeing those behaviors that are preceding and allowing this environment of contempt and disrespect to occur. One thing we really want to remember is we want to call them in for a conversation. It's really likely that we're going to be doing bystander training to learn how to call people out. One thing that offender rehabilitation and neuroscience has proven is that a shamed brain doesn't learn. It's really unlikely we try to shame someone into changing a behavior. They aren't going to want to walk through that door of accountability and to walk back the behavior. So we really take a curious and not a furious approach. We do that through taking a line of inquiry and asking questions. If someone is telling those problematic jokes that support, that victim blaming and rape culture, and have you always thought that way? We've been friends for a really long time. I've never heard you tell jokes like this before. I'm just wondering where you've heard that. And if we can learn as bystanders to hold that space, to allow people to step in, to have conversations about behavior, we can ask 4 to 5 questions first before we make a statement. There's real growth in those conversations. And I learned that when I started implementing some of these principles, that when I was uncomfortable when things were happening in rugby club environments and I didn't say anything, it's only now I'm speaking about it that everyone around me was saying, I was really uncomfortable when so-and-so did this as well. But I didn't have I thought I was the only one. We submit to this, what we know from social science is pluralistic ignorance, where we privately reject a norm and go along with it anyway because we incorrectly assume that everyone else agrees. So oftentimes we sit there thinking we're the only one that's uncomfortable with something, and nothing like a little bit of curious conversation to bring people in, to talk to someone who's on the receiving end of the behavior if they need support, unconditional and non-judgmental support. We hold the people who are using the behaviors accountable, and then we talk to our friends around to say, conversations like this make me feel really uncomfortable. And then it becomes about the behavior, and it also attaches a feeling to it as well that allows us to actually start to talk about the behaviors that happen and not shaming and excluding people who might be using them.
Yeah, fantastic. Thank you, Dean. Look, we've actually got some questions coming through, and I think we might go to some of the audience questions. And if you have any questions that you'd like one of our panelists to answer, please feel free to put them in the Q&A post now. We've got some in there. But I thought before we take questions, just sort of, building on, Dean's comment around some of the particular prevention program and bystander intervention program that he's talking about, that I thought it might be valuable to actually share some of the education and prevention initiatives that we're working on here at UOW. So at UOW, our student support and prevention work is led by our Safe and Respectful Communities team, known as SARC. So SARC provides individual student support for those who wish to make disclosures of sexual harm. They investigate instances of sexual harm and gender-based violence, and also lead our education and prevention work to prevent gender-based violence, both on campus, but also more broadly, because we know that obviously sexual harm is part of a wider societal issue, and we seek to provide support to all students. But some of the key education and prevention initiatives that are currently happening that I think are really, really exciting is the consent education for students first and foremost. So at UOW, all students are required to complete an education model in their first session at UOW addressing consent issues. And really, we've got so far, I think it was more than 27,000 students that have now completed that module. And that is, I think, a really key a key point of being able to really influence students and talk to them about consent issues as they navigate their university life. A couple of other initiatives that really jump out at me is the Set the Bar initiative. So that's a training program that's been developed and delivered to staff at our licensed venues across Wollongong. It enables them to identify, call out, and hopefully put an end to inappropriate behaviour and harassment in their venues. And to date, we've had around 100 staff from across 11 licensed venues that have completed the training. And it really aims to provide guidance for staff on what to say and do if they see or they are told about instances of sexual assault or sexual harassment. And as a university town, obviously this initiative is part of SARC and the university's wider work with our community partners, which is, really important work. The other partnership is a Ride with Respect program. So that's an initiative where we've designed, designed to target bullying, harassment, and other harmful behaviours that are occurring on local public transport to or from or around UOW. And it's an initiative that's been co-designed with some of our students here at the university. So we've worked with design students from the School of the Arts, English and Media to develop a promotional campaign whereby we will have, some material on our local buses targeting people around bystander training, and also have a link to, information about how they can be an effective bystander and, all of that really kind of supportive information for students on how to be that bystander. And we've got a phase 2 of that rolling out in the first half of 2024, which will be exciting. And part of that will be about training bus drivers in bystander intervention. We've got the bystander training that, Dean's already spoke about to our senior male leaders here at UOW, and, other initiatives like the development of trauma-aware teaching resources, UOW Respect Week. We've got a lot of exciting stuff happening, and the work that SARC does at UOW is really exciting. And in fact, what I will do is put a link in the chat to the 2023 SARC annual report, which gives an overview of some of the work that I've talked about and some other of the education and preventative work that's happening here at UOW. So I'll put that in the chat, and you might want to check that out.
Yeah, it's really fantastic to hear a lot of those initiatives going into public transport, licensed venues. That's fantastic because the role of a bystander is never to solve the problem, but to contribute to the solutions. And if I know from my experience of working within the system that hour and a half program that I facilitate a week was sometimes the only place that person was held accountable. And I know that can't be the only place that they're held accountable. They need to be held accountable at rugby clubs, university campuses, by the bus driver, and everywhere they go, they get that same message of accountability around respectful behaviour. And that's when we'll see those true ripple effects of change throughout our communities. So really, really great initiatives.
Yep. Fantastic. Yeah, I agree. Really amazing work in partnership with really key groups and people within our community. I'm very, just thrilled with the level of support that we get and the level of partnership work that we have available to us. Okay, let's go to some questions. I can see we've got a lot of great questions here. Thank you so much, and do keep them coming. If we don't get to them all, then we will find a way to actually respond to them. But let's go to our first one. So Julia, we have a question here from Robin asking, have all states and territories adopted the same protections for victims in court?
A great question. Part of the effect of our federal system is that, of course, each state and territory controls their own criminal laws, which does mean that the landscape differs across Australia. But by and large, what we have seen, particularly in more recent years, is that there is what I refer to in my work as kind of interjurisdictional borrowing. So one jurisdiction brings in something and everyone else looks around and goes, oh, that looks good, I'm going to have some of that as well. So they introduce it in their laws. So in terms of those general protections, pretty much most states and territories have the capacity for alternative procedures for giving evidence. Usually courtrooms are closed and there is typically some sort of procedure for non-identifying complainants. So some of the, and support people being present in the remote location or with the complainant if they choose to give their evidence in the courtroom. So a lot of that is quite consistent. In terms of the move around consent, most jurisdictions have a version of the definition of non-consent being about free and voluntary agreement. And in terms of the more recent moves since 2022, June last year in New South Wales, we were the first to introduce the model of affirmative consent. ACT has it, Victoria has it, Queensland has it now. And the only states and territories, Tasmania has a slightly different version. Western Australia is currently looking at and has on its inquiry at the moment a discussion as to whether or not they will move to that particular provision as well. So there's not complete consistency, but I think both in this space and also what we've seen in the area of domestic violence is that there is a move towards national coherence. And of course, the Senate National Inquiry that reported earlier in the year has made specific kind of recommendations around national consistency in this space, because it really shouldn't be a matter for each individual to have different protections available to them depending on where they live. So I think that that's recognised that that's particularly important in this kind of area of ethical relations. So hopefully that's helpful. And but yeah, it is
absolutely.
a product of our federation.
Indeed. And actually, I might just ask another quick follow on to that, and then Dean, I'll come to you because we have a kind of a comment, a really interesting comment relating to, I think, the nature of what you were talking about. So I'll come to you. But Julia, a question here. It says, is there a danger with the communicative consent being implemented in the Crown's case, considering many sexual assault matters are in effect circumstantial evidence? In effect, circumstantial matters where it may be the accused's story against the complainant's story, where the defence will try and use some of these historic rape myths to attack the complainant's credibility. How can we prevent this?
That's the $3 million question, or maybe it's $10 million question. Look, I guess I would answer this in a couple of ways. You're quite right that at times, or the majority of sexual assaults, because we know they typically occur in private spaces, so usually in a residential location, and the person is known to the person. So we know that's the data. And that means that the capacity for somebody else to witness that sexual assault is significantly reduced. There's often no other eyewitnesses, so to speak. But there is often a range of other evidence which probably is circumstantial. Some of that, the role of CCTV footage has played a lot of significance in a number of trials that we've looked at. Evidence from medical officers plays a role. I think it should be quite a limited role. And then also the kinds of behaviours that people report about after the event. Now, some of that then merges into this kind of difficult area of, well, why should the fact that the complainant told a parent or a good friend and was distressed after the event mean that that particular report is more credible than it's not? And I would, we've got now jury directions saying things like there is no particular way that anybody responds to these kinds of matters. So it is very difficult because these are private matters. And I think there is no real incentive at the moment for, in particular, the defence to change how they attack that story. I mean, they are representing a client, they have particular instructions, they have to test the evidence. So in a sense, it's very difficult to change the nature of trials, unless, of course, a decision is made at some point as to introducing more barriers to those kinds of problematic lines of questioning that we see. And no legislature at this stage has actually attempted to prohibit those lines of questioning because, of course, the very important, and we haven't talked about this, the presumption of innocence and the fact that cross-examination is always given a very wide latitude in the courtroom, mean that it is hard to limit these things. But we are currently spending millions of dollars each year running sexual assault and rape trials, as it's known in Victoria and South Australia, and nobody is very happy with the outcomes. So I think we do need to look long and hard at what we're doing. I mean, I do interviews with prosecutors at the moment who say the district court and the county court in Victoria, for example, they're sex courts because the majority of matters that run are either child sex matters or adult sex matters. So I think there is incentive for the government and all of us to be trying to change this space because what we're doing at the moment is not working.
Yes, absolutely. Thank you. Thank you, Julia. Dean, a comment from an anonymous attendee says, I know a perpetrator of sexual violence who acknowledged his violence to friends and then was highly supported by them and excused for his behaviour. It has led him to believing he did not do something wrong, and then he's gone on to do more problematic behaviour. I agree with calling in men to act against gendered violence, but how do you stop perpetrators sometimes feeling excused and enabled by this model to continue doing harm? Any thoughts on that? And Julia, you may have a reflection on that too, but Dean, what's your thought?
Yeah, look, great question. And really how the bystander model would work is that obviously it would aim to prevent the act from ever happening in the first place, but then it would address the culture that allows victim blaming to occur. So as Julia's pointed out, the way trials are done on a victim blaming basis around resistance, around levels of intoxication, around all those sort of choices that have always placed the onus on the person who's the victim of the behavior. And that's really fed into community as well, where we see even publicised of the Bruce Lerman trial for a long time was put in newspapers as the Higgins trial, and as far as we were aware, she wasn't the one on trial. So it's really, I think, the culture around allows victim blaming to occur. So when someone would admit sexual violence to that extent, that culture of victim blaming from the bystanders around, they're doing what they see around them. And really the question is, it's not how do we stop men from doing this, it's how do we stop them from feeling entitled to do it? And that's when bystanders chip away at the victim blaming entitled pieces around that. And hopefully there would be a bystander in that situation that could say, and perpetrators of sexual violence obviously rely on us to not always have the information, and that's sometimes a big barrier for bystanders who might witness that and in that friendship group go, I wasn't there, I don't know, I don't have all the information, and therefore I can't step forward because I don't have all the facts to make a decision. And we often say a lot of the times you don't need it. You don't need all the information. They'll say, well, you don't know what happened. Well, you weren't there and you don't know what they did. And oftentimes as a bystander in that situation, you can say, I don't have all the information, but what I just heard then about what happened makes me feel really uncomfortable. And it sounds really unsafe. So I think what the bystanders would do is start to chip away at the culture that allows that to happen. And what we actually start to see is that when we talk about that level of pluralistic ignorance, oftentimes we're privately rejecting a norm and accepting a wider one because we're assuming incorrectly that everybody else is on board. So one person is excusing this behavior and giving them permission to essentially continue to do so. Others will go along because it's safe to do so in numbers. But when that's challenged, what we know through social science is when pluralistic ignorance is broken down and someone intervenes, usually others feel the same way and will join in that conversation as well. So Long story short, the bystander model would prevent that act from happening, and if it did happen, it would absolutely hold the perpetrator of that respectfully accountable, and also show support to the person who experienced it as well. So that's the long story to short of that, would be that the culture around that allows victim blaming to occur. It happens in some spaces and it doesn't happen in others, and those conversations start to change. Particularly, we use, for example, if you're having a conversation about religion at the dinner party table, when a person of that religion is there, the conversation looks completely different to if they weren't. So by being allies in that space, when you are hearing victim blaming occurring, it doesn't occur who will call people in for the conversation. And in that friendship group, it only takes one to start that ripple effect of change.
Thanks, Dean. Julia, I don't know whether you had any comments about that. Feel free if you would like to comment. Otherwise, I have another question for you, but would you like to comment?
Oh, maybe let's go to the other question, because I think Dean's
Okay.
done a job of, trying to intervene in what would otherwise be the repetition of really problematic behaviours. So yeah, thank you, Dean. Yeah.
So one of the other pieces of work that I know you're doing, talking about education and prevention and all of the issues that we've talked about, is the judiciary. And I know that you have been training, both prosecutors, lawyers, and judges for, some time now. I just wondered if you had any reflections broadly on that space, on the kind of education and prevention in that space.
Yeah, look, I think one of the methods I try to use is, rather than just talking in generalizations, either in academic voices like about rape myths, and I know I've used those words here, and rape attributes, what I like to try and do is to draw on the trial transcripts and show forms of cross-examination that are contrary to what the legislation says. So when I'm talking to the DPP or to defence lawyers, it's to show a line of questioning that would actually be either objectionable or shouldn't be admitted for one reason or another, to really draw out that these are things that are going on in courtrooms around us, and to give them a very practical example of what should change. And that's in part easier to do with the Crown because, and somebody was asking this question before, and I said, there isn't that much incentive, I think, for the defence to change their behaviour, but I'll come to why there might be a little bit more of that. But so to say to the Crown, for example, when a line of questioning is about, so you didn't say anything, you didn't do anything, you didn't scream out, is now for the Crown to be empowered to say in submissions to the judge, well, you've heard my friend, non-consent has now been proven beyond reasonable doubt effectively, because there's now no evidence indicating otherwise. So the only question should be left in play is whether or not the accused knew that the complainant was consenting. So to really kind of try and rehearse for the Crown the ways that they could be intervening in current trials. With judges, the other thing that I've found has been useful and important is to have examples of best practice. And so I kind of have hero judges in some of the transcripts that I've read. And just to take one example, in Victoria, they have a very strong direction on delay. It's the strongest, I think, in the country. And what it has to happen is that at the time, or even before evidence about delay is raised, they can give a direction. And one judge in particular was extremely good at doing this. And what they would say after some line of questioning, they'd send the jury out and they'd say, Mr. blah, 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 or Ms. blah, 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 you've now opened up delay. I'm going to give the direction. And they would say, no, we haven't done that. We haven't done that. We were just going to whatever. And then they bring the jury back in, and immediately a very strong direction was given after the evidence and after that kind of particular thing. And I think that had the capacity both to change the behaviour of defence counsel and also to have an immediate impact on the jury to be told what's going on and what they should actually, how they should analyse that evidence. So it's trying to give quite practical examples of how things can change.
Okay. Fantastic. We actually have a really good question up here, but unfortunately we can't answer it because we will be cut off at 5 p.m. But actually it's a question that if you wanted to reach out to me, I'm happy to direct that question to Julia. It's a really interesting one, Julia, about different conviction rates in city and metro and country areas, and we've got a New South Wales prosecutor asking that question. So if you reach out to me, I will direct that to Julia because it's a really interesting one. But I need to wrap up now and say we are out of time, but I want to say a huge thank you to Julia and Dean for joining us this afternoon, for your fantastic contributions. Thank you also to our audience for joining us. Really hope you enjoyed the discussion. This event was recorded, so anyone who is registered will receive the link, and we will have this available for public viewing as well. But thank you, everyone, and good evening.